Please be seated. Good morning. We are here for oral argument in cause number CV210612, Helvetica Servicing versus Michael S. Pasquan. These proceedings are being video and audio recorded as well as live streamed, so we ask counsel please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes in which to present their argument. Appellant's counsel is responsible for using a portion of that time for rebuttal should you desire. We have read the briefs. We have discussed this case in conference. We are familiar with the facts of this case. Please bear that in mind during your presentation. At this point, counsel, are you ready?
Yes, Your Honor.
Please proceed.
May it please the court, Jason Goldstein of Buckhalter on behalf of Helvetica Servicing, Inc. We've been here before, and I appreciate that you guys know all that has gone on in the cases. And I'd like to just start off with, there was a house on the property before Helvetica or Desert Hills made a loan on it. Pasquan put in approximately $500,000 worth of improvements in there before he obtained a loan from Desert Hills Bank or from Helvetica.
Isn't it a little mild to call them improvements? It really was just one, as I understand it, like one wall left.
The finding of fact, I believe it's 28E, is that over 50% of the original structure still remained. While there may have been many of the walls removed and only a few that were there still is a large part of the existing structure. There was the garage or the that was turned into part of the house. And I still think it is improvement and not construction in the sense that we're working on, because I think the critical point is elective enhancement, and that is what occurred here. There was a house that was there. It was slowly...
What is our review for these things, though? I mean, as evidenced by the discussion between you and Judge Howe, it seems like there's a kind of a factual dispute between how much was this destroyed, replaced, rebuilt, etc. Why is it our role to weigh these things differently than what the Superior Court did?
Well, I'm not disputing the factual findings of the court. I'm disputing the conclusions of law that the court reached, and I believe that that is a de novo review for this court. I mean, the facts that were found lead to the conclusions I believe that this court should reach, which is that this was a home improvement loan.
Well, but the five factors seem factual to me, and for the Superior Court to make.
I think there's the legal conclusions that have to be made based upon what the facts are. In the trial court's opinion, there are approximately 60 facts, and then it goes into the conclusions of law. Based on those facts lead to the conclusion I respectfully hope this court would make, would be that this was a home improvement loan based on the five factors, because since the underlying facts are not disputed, this is really just a question of law for the court on undisputed facts. Each of the facts that are in there lead...
I'm now confused. You're asking us to affirm the Superior Court?
I'm asking you to reverse the Superior Court because the conclusions of law were incorrect based on the facts that were deduced. The determination that this was a construction loan versus a home improvement loan was a conclusion of law based on the facts.
Well, can you just keep asking? I thought you just said twice you need to affirm that this was a home improvement loan.
My apologies if I misspoke. The
Okay.
court needs to reverse the trial court's finding that this was a construction loan and find that this was a home improvement loan, in particular because this is an elective enhancement project, and based on the facts, that is the only conclusion that could be reached.
Okay, so while something is a construction loan or a home improvement loan is not a legal question as far as I understand it, it's a factual question. Is this a construction loan? Is it a home improvement loan? I mean, so I don't know how that's a legal determination, but just Capinero, reviewed the record, took evidence, and made a factual determination that this was a construction loan.
In the trial court's opinion, it has a separate section from facts, and then it has the conclusions of law based on those facts. I believe based on the facts that are there, it does lead to the conclusion that this is a home improvement loan, and this court is allowed to review that de novo, which is what we're requesting to do here. I think based on the guidance that the Supreme Court gave, in particular paragraph 17 and 18, where it described it as a construction loan may involve building an entirely new construction, but it also includes building or rebuilding qualified properties. But then it goes on to explain below that, conversely, a home improvement loan includes elective enhancements, such as the expansion of an existing structure, which is what occurred here, but not reconstruction of a damaged structure. I think that goes to when you look at the factors which are non-exclusive, and you're supposed to look at the totality of the circumstances. I believe the most important factor is whether it's inhabited or inhabitable or inhabitable. And here, I think some bright line rules can be reached. If it's habitable during this process and it's an elective procedure, then it's home improvement. I think that's a bright line rule that this court could make. If it's uninhabitable due to damage that was caused to the property and there must be reconstruction, then that could be considered a construction loan. However, if it's uninhabitable due to the elective enhancement, I think that leads to the bright line rule that it is a home improvement loan. You can't just damage
Don't you
your
think
own.
if the Supreme Court had wanted to tell us there are bright line rules, they would have said there are bright line rules? I mean, they gave 5 factors and said to weigh these. There's no discussion in Helvetica 4, or whatever it is, that there's one thing that is dispositive, that there's a bright line rule anywhere. So what's your authority for saying there's a bright line rule we need to follow?
I'm saying there could be a bright line rule. The Supreme Court gave the 5 factors. They're non-exclusive. I'm saying that I believe that is the most important factor.
So you would like us to adopt a bright line rule separate from when the Supreme Court told us 5 factors, non-exclusive, weigh everything, totality of the circumstances, you're saying we should adopt a bright line rule.
I'm saying that as part of making your decision, that can be the most important factor since it's not exclusive. I think the second most important non-exclusive factor is number 1, which is whether there was a complete demolition or substantially complete demolition of an existing structure and a new building put in its place.
Was there a substantial demolition in this circumstance, or in this case? Didn't the court find it was largely demolished?
The court did find that it was largely demolished, but it
Is that different than substantially demolished?
Yes, I would think it's lesser.
I don't know, I'm just asking.
Right, yeah. But I would say that the key part is on a new building constructed in its place with that factor. I have a 1965 Mustang, and if I replace 50% of it, it's not a new car. I didn't purchase a new car. All I did was fix up my 65 Mustang and made it better. I could put in a blower on it. I could do all sorts of things. And that is what Pasquan did here. Pasquan had an existing house and made it bigger.
When we look at what he did, your Mustang analogy does not add up because the Mustang still is the same size and looks the same on the outside as it did pre-restoration or fixing up or improvements. Here we have a structure that went from 4,000 square feet to 11,000 square feet. That's a substantial difference in the exterior size and habitability space square footage of the dwelling. So at what point is it home improvement? Is it construction loan? I mean, this is basically an entire additional house, bigger than most people's houses, added onto this dwelling. So how do you rectify that?
I don't believe that the use of square footage should be dispositive. The average Joe homeowner is not going to be able to add 11,000 or 6,000 square feet to his house. Is that person not going to be protected by the anti-deficiency statutes if he's rebuilding his house and he only has to put on or just rebuilds a portion of his house that was destroyed by fire, flood, or earthquake? So I don't think the square footage should be the dispositive issue. That would go under the elective enhancement.
Well, no one is saying that square footage is dispositive, but when the court finds as fact that the property was largely demolished, and says all that remained from the original structure were 3 walls and part of the foundation. That sounds like a substantial rebuild, not quite a home remodel by putting in a new island in the kitchen.
Well, my view would be that a rebuild is something that is required to be done due to outside circumstances. Elective enhancement is taking something that you already have and making it grander. This was not something that was required to be rebuilt. It wasn't rebuilt. It was enhanced and improved. I think that the Supreme Court, who we've now...
So if they had just taken a wrecking ball and knocked down the entire building electively and then rebuild a new house, would that be a construction or would that be a remodel? Where are you getting this outside, something must force them to do it? That's what I'm confused by.
In the Supreme Court opinion, when it's describing the difference between construction and home improvement, it states that elective enhancements such as expansion of an existing structure is home improvement, which is what I would posit is what the undisputed facts show occurred here, but not reconstruction of a damaged structure. We have now, as the law in Arizona...
That's one sentence, but there's other sentences in there that talk about the 5 factors, again, that you look at and doesn't require an outside influence. So, I mean, maybe that's the bright line they're saying, is it's clearly going to be construction if it's because of damage and the house is destroyed or burned down and you have to rebuild it. But then if it's not in that, then you look at the 5 factors. Isn't that the way to read Helvetica 4?
I would agree that then you look at the 5 factors, correct, but I think that if you go to the totality of the circumstances, first of all, or the guidance they give on what's the difference, and when it refers to elective enhancements, I think that is critical. And also, I mean, if you go to the habitability versus inhabitability, if it's done by your elective state of improving it, I don't think that favors a construction loan. That favors you having the wherewithal to improve your home or expand it beyond its initial condition.
So back to my hypothetical then, if we've got a perfectly habitable house, but I decide I'm going to wreck it, I'm going to take a wrecking ball to it and destroy it, and rebuild a new house, what is that? Where does that fit within the test?
I would think that if you destroyed down to there's nothing there left, and you
leave the foundation.
Leave the foundation,
yeah.
And you then get a loan to build up the house, that's plenty. And that's what was discussed in Helvetica 1.
Sure.
And I would think that is fine.
But if I leave one wall or 2 walls, then it's different?
Well, there's 3,500 square feet of the original structure. That's fact 28E.
That seems to be a fact, but I mean, we have the fact finding being largely demolished with the final product being twice as large. All that remained from the original structure were 3 walls and part of the foundation.
There was never not a home that was on the property. There was never not a home that was livable.
Okay, but you agree with us. We're bound by what the trial court found as far as facts, unless it's clearly erroneous. And you're not challenging, you told me at the beginning, we're not challenging the fact findings.
I'm not challenging what the facts were. I'm challenging what the conclusions of law were from those facts. And I believe that those facts demonstrate that this was improvement, that this was elective enhancement. And going through the 5 factors, the proper legal conclusion, this was home improvement.
So Mr. Pasquan's error then was in trying to preserve what could be preserved, he should just knock the whole thing down, and then we wouldn't be here.
Well, what happened with Mr. Pasquan is that he had an existing home, spent $500,000 on the improvements before he got any subsequent loans, and then he decided he was going to build for a profit and to finish what he started. This was never a rebuild. This was a remodel that went out of control, and the loan from Desert Hills was to finish what he started. And in fact, going to the tracing argument, even if this court were to disagree with me that these loans were home improvement, there's still the tracing aspect. And based on Trial Exhibit 35, which is Pasquan's own description of what happened with these loan funds, he says that, and the trial court found, or since this was all deemed to be purchase money other than $60,000 minus a fair market value credit, was that reimbursing himself for $350,000 of a down payment and for doing $500,000 of improvements before the loan, that's called cash out. That's not getting a loan to do anything. That's reimbursing yourself from something that's already done. The loan proceeds from Desert Hills were used, in fact, to reimburse based on the exact description of the trial exhibit, and those could be traced. Either way, the deficiency amount of $30,000 is grossly deficient. I believe that the undisputed facts compel the conclusion that these were home improvement loans and are not protected. And then, just because I want to try and reserve a few minutes.
I appreciate your time, but a question I would like I'd like to talk about is the argument of gettable accounting, the fair market value, because I think there may be some merit in that.
I think that was the last thing I wanted to hit before I reserve my time for rebuttal. So the fair market value credit is a means to lower a deficiency judgment at the beginning by taking what the fair market value is normally through an appraisal and deducting it off the top. At that point, you're left with the number that should be the deficiency judgment. So they've already received the fair market value credit there, and then the rest of the work goes on from there. I also believe that the fair market value credit is protected money. It's protected from being able to go after on a levy. So I think that if the purchase money portion, here we have $600,000, is protected and the fair market value credit exceeds that, you don't get double protection. But in any event, once you get the fair market value credit and you get a deficiency judgment, there's nothing in the statute that says that you can then create some percentage to deduct that. And so with that, I'd like to reserve my last 4 minutes and 10 seconds for rebuttal, and I appreciate the court's time.
Thank you, counsel.
Thank you. If it may please the court, I'm Daniel Cloberdance on behalf of the defendant and appellee in this matter, Michael Pasquan. As I can tell from the questions, the court's well aware of the standard review that should be applied in this case. And I was also going to add that not only should the appellate court defer to the trial court's findings of fact, unless clearly erroneous, the court should also view the evidence and all reasonable inferences in the light most favorable to sustaining the Superior Court's ruling. And I think the court's well aware of that standard. And
Okay, so is the question whether it's a construction loan or a home improvement loan, is that a factual matter or is that a legal matter? I want to make...
And that's a good question. The Arizona Supreme Court stated in Helvetica 5, the case that's controlling this matter, that it remanded this case down for a factual, intensive inquiry. So the Arizona Supreme Court recognized that the test to determine whether a loan is for construction purposes or for home improvement purposes or for other non-purchase money purposes is a fact-intensive inquiry. So you do have to make a conclusion, and a conclusion of law, that this is a construction loan, but it's based on a fact-intensive inquiry with those 5 non-exclusive factors and the totality of the circumstances, all of which Judge Campanello did in excruciating detail in his ruling. So ultimately, it's a conclusion of law. I would agree with counsel on that, but it's entirely based on a fact-intensive inquiry and a question of fact, and it's very clearly stated. Multiple portions of the Helvetica 5 decision where the Supreme Court says that.
I'm going to kind of push you the opposite of what I pushed counsel, because I'm confused by what we're supposed to do after Helvetica 5. We have very explicit language from the court that says elective enhancements, such as the expansion, are home improvement loans and aren't subject to the anti-deficiency provision. Then they give us this 5 factors. How do we reconcile those two? Because I agree with your opponent that this was an expansion. It was a huge expansion, but it was elective. No one was forcing him to.
And I think you alluded to this earlier, is if the Supreme Court meant that was a bright line test, that an expansion is not going to be a construction loan, the Supreme Court would have said so. Instead, it gave us these 5 non-exclusive factors and a lot of analysis that should be entertained by the trial court in making that determination. So there's language I could read portions of the Supreme Court decision and say this is conclusively in Pasquan's favor. Also,
Give me some of those, because I would like to see some of them.
Yeah, yes. I mean, you've got the Supreme Court says, quote, whether a home improvement loan or construction loan, quote, depends on a number of criteria, and held courts, quote, should consider the totality of the circumstances surrounding the loan, unquote. And then the court identified the 5 non-exclusive factors indicating whether a loan is a construction loan versus a home improvement loan, and thus entitled to protection. One of the factors is whether there was a complete or substantially complete demolition of an existing structure and a new building constructed in its place. By using the word substantially complete demolition, not just an inference, but that cannot mean anything other than that you're not disqualified from protection just because you've got a less than something that's a total demolition of the house. Otherwise, they wouldn't use those words. And they wouldn't have remanded the case to begin with, because the record was clear that this was a project that was done in stages, and the record was developed well enough for the Supreme Court to look at this and say, this is done in pieces. There's a portion of the original structure still surviving. There's 3 walls that survived. Parts of the foundation survived. But as Judge Campanella found, there's total, not total, but almost virtual total change in this house. And he identifies those as
eviscerated.
Yeah,
the house
yes,
at some point.
exactly. Another factor is the intent of the parties when executing the loan documents. The most important document here, and it's attached to the appendix, to our appendix for Pasquan's open answering brief, is the loan application itself.
That was for a construction loan.
For refinance of a construction loan. That's heavily in favor of Pasquan. Is that conclusive? No.
Well, but he also said that he intended to sell it too.
He did, right. And that's an issue that's addressed. Well, let me go through the next factor. Third factor, whether the structure was inhabitable or inhabited during construction. Judge Campanella goes into great detail about that particular factor, and I'm going to quote from his ruling at paragraph 56 of his findings. As stated earlier, Michael Pasquan resided in different portions of the Fanfull house during the bulk of the expansion. He stated that he moved out in 2006 when the Fanfull house was secured. However, the evidence shows that the Fanfull house was not fully habitable, and in fact was only habitable on a room-to-room basis as the expansion continued. So Judge Campanella considered that factor, and it's a non-exclusive factor. The fourth factor, the Arizona Supreme Court stated, is whether the structure was largely preserved and improved or substantially expanded. By implication, that means exactly this situation does qualify for anti-deficiency protection if the court finds that, based upon the totality of circumstances, this really is a construction loan versus a home improvement loan.
Is the warning from all the litigation in this case is you shouldn't have left the 3 walls and part of the foundation? Because if he had done that, where would we be here?
Well, right. I mean, there is, or if he tore the whole house and rebuilt it, I don't think the question would be here. We probably would have finished this case in 2012 with the first Helvetica decision on whether or not a refinance qualifies for anti-deficiency protection, because that was the original issue that the Helvetica 1 determined, and also determined that construction costs are purchase money as well. So I would agree. If that were the case, I think we would have been done with this case literally 10 years ago. But it's clear from the Supreme Court's decision that the court recognized this home was built in stages, recognized that not all of this home was torn down, but parts of it were preserved, and it was largely expanded, and it was an existing structure that started with. The Supreme Court recognized all that. And yet they didn't say, you lose because you don't pass the bright line test. There is no bright line test in this kind of situation. There are multiple factors.
Well, because I keep thinking about the standard of review. I mean, we can look at the record and what happened here, and we each have our own opinion on how much of the how much of the structure was rebuilt. But is our standard of review on that an abuse of discretion, and whether Judge Campagnola's findings of the fact were reasonable or clearly erroneous?
Clearly erroneous is the standard, and reasonable inferences are to be, upheld by this court as well. Yes, the standard of review for the ultimate question is clearly erroneous, and Helvetica's they're not able to point to anywhere where Judge Campagnola made any mistakes in his factual findings. In fact, they agree that this factual findings, all his factual findings stand. And if you read the factual findings that Judge Campagnola, again, in excruciating detail, has put forth here, there's really no other logical conclusion that this is a construction loan under the 5 non-exclusive factors and the totality of the circumstances. The 5th non-exclusive factor is whether the project is characterized as a home improvement or construction loan in the loan documents or other official documents. Here we have the vast majority of the refinance the Desert Hills construction loan. The construction deed of trust that's recorded is called construction deed of trust. That alone, if there were nothing else in Pasquan's favor, that alone would give the trial court authority to determine that what was refinanced was a construction loan. As Judge Campagnola also points out, Michael Pasquan testified that there were draw requests with that Desert Hills loan, which is indicative of a construction loan. Judge Campagnola also determined that the Helvetica loan, the loan that we're here fighting over, was a 12-month bridge loan, which is an indication that it's a construction loan. So there are many factors in favor of Pasquan here, and ultimately what Helvetica is arguing is let's go back to the Helvetica 4 case that was vacated. That's really what they're arguing here. He's being a little more clever than that, but that's ultimately what the argument is here. Let's forget these non-exclusive factors and go back to the bright line test that was flat out rejected by the Arizona Supreme Court. And in this court shouldn't do that.
Can we move on to calculating the deficiency?
Yes, and
it's math, and I know from Compass, many of us like math here.
Let me explain. Yeah, and going. I've never seen a ruling with this much detail before. I doubt if many comes across this court. And there's a lot of numbers.
Well, and I'm trying to cut you off. I just want to explain at least where I'm coming from. Is it seems that there's an amount borrowed, then you subtract from that the fair market value, and that's the deficiency. And part of that is purchase money, and part of that isn't purchase money. Isn't that the end of the matter? I applaud Judge Campagnolo for how detailed his analysis was, but it seemed to me that he went too far after he did what he did. Then why do you take out a portion of the fair market value out again?
Yeah, let me explain. He did take it out again. Think of this as a company with 2 sets of books. We've got one book that's going to determine the deficiency amount that was due to Helvetica at the time the sheriff's sale was conducted, because that was in 2009, and that's when you would apply the fair market credit. We all agree these numbers were stipulated. The amount of the loan as of the sheriff's sale date in 2009 was $4,203,000 and some change. We all agree, because the court found such, that the fair market value of the property on the date of the sheriff's sale was $2.266 million. So the deficiency amount, if we set aside the anti-deficiency statutes don't exist, or this is a commercial loan, the deficiency amount at the date of the sheriff's sale was $1,936,825, and that's throughout his opinion. Now that number doesn't tell you anything about what Pasquan owes for purchase money versus non-purchase money. That's the total balance of the loan without consideration of any purchase money. It doesn't take into consideration the $600,000 loan that was paid off. It's just the raw numbers. This is the amount of the loan that Helvetica has. This is the fair market value credit. This is the difference, $1.9 million.
And Helvetica Caponello decided that 61,905 and then was non-purchase money.
Right, and the way he determined that, and this is if you go back to his ruling at page 40, starts at page 39, but really is page 40. That's the key to the whole case here. Forget the amount of the deficiency for now. What Judge Campanella did, and correctly so, was he determined how much of the $3.5 million loan that Helvetica made originally was purchase money versus non-purchase money, or construction costs versus non-purchase money, other things that don't qualify for construction costs. So you have a $3.4 million loan. His job is to trace and segregate the purchase money and non-purchase money aspects of that $3.4 million loan. And he did this on page 40, paragraph 127, where he determined that the construction costs were $2,010,000 and some change, but based on the testimony and all the trial exhibits. He included the $600,000 original acquisition loan to Hamilton, which was refinanced with the Desert Hills loan, and I don't think that can be disputed. And then, and this is where the numbers might get confusing here, he determined that the settlement costs per the settlement statement, which exhibits 20 and 40, were $500,153. And he specifically found that these were fees and expenses normally associated with the closing of a construction loan. And that's the Klassen test. In Klassen, this court held that if it's a purchase money loan, the interest and late fees and required construction deposits are considered purchase money as well. So all those loan fees and costs that Helvetica charged are included in the purchase money aspect. And then he also determined that there's $227,885 for 7-month interest reserve that Pasquan paid interest with to Helvetica, and under Klassen, that's purchase money as well. And what Judge Campanella determined was the total purchase money portion of the $3.4 million loan was $3,338,096.50, leaving a balance of $61,902. So the deficiency amount is that Judge Campanella determined is $61,903. That's the non-purchase money portion of the $3.4 million loan. Now, where the fair market credit comes in, keep in mind that we haven't used the fair market value credit yet for those numbers. So when Helvetica took the house back, they foreclosed the house, they take title of the house, that's a credit towards the borrower. It's akin to a payment. And so there's a $2.266 million credit that Pasquan's entitled to. How do you apply that credit? That's a good question. I argued this is consumer protection laws. The credit we should apply that portion towards the non-purchase money portions for consumer protection. Helvetica argues, you should apply it all towards purchase money, which would obviously makes a big difference. If the court had applied it all towards the non-purchase money portion, as I was urging, kind of half-heartedly because I felt it wasn't right, there would have been no deficiency at all. And instead of getting almost a $500,000 judgment, Helvetica would have got $0, and Pasquan would have got his attorney's fees.
So the 61,902 then is a portion of the total loan that's non-purchase money, regardless of the fair market value.
Right, $61,902, that's the non-purchase money portion of the $3.4 million loan. And now that was the original loan. Now we have a credit that we have to apply. What Judge Campanella did, and it's really the only logical way to do it, is I'm going to prorate that. I'm going to look at the total balance that was owed at the sheriff's sale, And I see that 46.08% of the loan is paid off.
Why is that the only logical? Because it seems to me at that point that you start double counting it when you
No, because the
prorate
loan,
it again.
because it hasn't been counted yet. The fair market value credit it hasn't been used. Now, you got all these calculations that Judge Campanella's got in his minute entry, but there hasn't been a credit towards the $3.4 million loan, and specifically the $61,000 of non-purchase money. There hasn't been a credit yet. Just think of that as Pasquan in 2009 writes a check to Helvetica for $2.66 million. What do you do with that? He's just paid off 46% of the loan. And that's why Judge Campanella did all the calculations. He was not to determine, not applying the fair market value credit wholly to Pasquan, but determine what portion of that fair market value credit should be applied towards what he determined was the original non-purchase money portion of the $3.4 million loan. So it's not. It's hard to read. I understand that, but it's not. He did not apply the credit twice towards that $61,000 figure.
We have struggled over this. I've struggled over this. I never really understood the 46% business. It seems to me that 61,902 is like 2% of the total loan. And wouldn't you just, if you were going to do it this way, wouldn't you just apply 2% of the fair market value to the non-purchase money?
I think if you did that, I think you'd end up with the same number. If you did it that way, there's different ways to calculate that. What Judge Campanella did was he took the percentage of the payment, the loan had been paid off 46%, and he applied that same payment based on the share sale valuation date towards the $61,902 non-purchase money portion. And he prorated. He did not apply, I want to emphasize this, he did not apply the fair market value credit twice. Those are apples and oranges, the amount that's owed at the share sale date, and then determining what portion of the non-purchase money portion of the loan was actually paid off by virtue of the share sale.
Counsel, your time is run.
My time is up. Thank you very much.
When you're ready.
Thank you very much. Just one quick point to make. When counsel was referring to the inhabitability or lack of inhabitability question, he was referring to the actual conclusion of law. It was not to the fact. The actual fact is at 63, and it says Michael Pasquan testified that he resided in the Panhandle Hills for the bulk of the expansion period. The issue that I believe this court can decide is what is the actual legal conclusion from the facts. I think we both agreed at this point, at least on this side, that the ultimate conclusion made by the court by the trial court was a legal conclusion as to whether it was home improvement or construction. And based on these facts, this court can make that determination.
This reminds me a lot of, in the criminal sphere, the probable cause analysis. The trial court gets to find all the facts that happened below and whether suppression was, or whether the stop was legal, et cetera. But then we still have to apply a legal analysis to those facts to determine whether, so we review their factual findings for clearly erroneous, but the legal conclusion as to whether probable cause was established is de novo. Is that kind of what we're at here?
I've not been much in the criminal sphere, but I do believe that based on the facts, this court can make the conclusions of law and determine de novo whether or not those conclusions were in error, and I believe that they were. Just a couple quick points.
Can I ask you a question, because I don't want you to run out of time? Was the fair market value accounted for double? Your opponent says absolutely not. I want to hear your best argument for why it was double counted.
Because it was double counted, because when the credit was applied for, it was given to the balance that was then due at that time. There is no place in the statute that says you get any other benefit of that fair market value credit. Whatever arguments are made later are made later. They have nothing to do with what the effect of the fair market value credit is. The effect of the fair market value credit is just to lower the amount of the balance. And there's nothing in the statute that says anything to the contrary, and there's no case that I found that states anything to the contrary.
Thank you.
Council brought up the fact that the Desert Hills Bank deeds of trust said construction on them. As this court is well aware, there was no issue of what a construction loan versus home improvement loan was at that time, so I don't think that is dispositive. And the word construction can mean lots of different things in practice. You hire a contractor, he constructs something, it could be an improvement. It doesn't necessarily mean you're building a damaged residence or you're building a house from scratch. Also, I point out that the court, or strike that, the deed of trust, the Desert Hills Bank deeds of trust refers to the UCC, and I cited cases in my brief that refer to a true construction deed of trust being a loan that's used to purchase the land and finance the construction on it. So I think the title of the document in and of itself has to be further analyzed with respect to the UCC provisions that are referenced therein. Also, just want to point out that there still is the tracing analysis, and I think that no matter what, the $30,000 deficiency judgment is clearly erroneous. The amounts that were spent before the Desert Hills loans or Helvetica loans were obtained are not used to build a qualifying residence or for any purpose. It's reimbursement. It's getting cash out and giving it to yourself. Those monies were already spent. He had already purchased the house with a $350,000 down payment approximately. He'd already put in $500,000 of his own money into improvements. You get a loan later. That does not mean that all of a sudden stuff that was previously done was used for that purpose. That's getting cash out and using it. That is not what the anti-deficiency statutes were designed to protect. Helvetica 1, abdicating personal responsibility, stretching these anti-deficiency statutes beyond anything the legislature could have ever imagined, and I appreciate the court's time.
Thank you so much. Council, we thank you both for your arguments here today. We will take this matter under advisement and issue a written ruling in due course. We are at recess.